Thanks so much for being with us here on Atlanta News First Plus. I'm Joy Lim Nakran. Just wanted to get on here and invite on our special guest, local Atlanta attorney Justin Hill joining us. And he's here today to discuss the Supreme Court decision essentially striking down race-based affirmative action. This was brought about by a case against the University of North Carolina and against Harvard University and their race-conscious admissions program, which the Supreme Court ruled violated the Equal Protection Clause of the 14th Amendment. So Justin, I know this is a case you've been following, we've all been following very closely. What's your reaction?
So my reaction is it's definitely an interesting decision. I'm interested to see the implications that this could have on admissions of black students and minority students moving forward in the future in admissions.
And we know that the plaintiffs in this case, against the University of North Carolina and Harvard University had argued that these race-focused admissions programs essentially discriminated against, Asian American and white applicants. And this largely conservative court ruled 6-3 that essentially that the best way to end racial discrimination was to remove race as a consideration. Correct me if I'm wrong, if that was your interpretation of the ruling.
So in the gist, yes. So I guess to be a little bit more specific, the Supreme Court reviewed the specific standards and criteria of both universities, and what they were really looking for and what they assessed in their analysis was the criteria had to be something that could be measured by the Supreme Court. And they also said that there had to be an endpoint for any race-based criteria in admissions as well. But from looking at their criteria, they were not able to find anything that they could, I guess, tangibly measure as far as how successful it was or how accurate it was at achieving their goal. And also, they did not see an end goal or an end in sight for those measures as well. And one thing interesting that they did say, as far as the only thing that they left open for race-based was, and I guess in the context of an essay, a student could just discuss how their particular race impacted their life and their experiences and what value that could bring to the institution. But that was the limit. They couldn't look particularly at that race as a plus factor in that admissions criteria.
That's a really important point that you brought up, that because students going forward, who are applying to college, who are planning to apply to colleges, if race is something that they feel is important to them, they want to know, what do I do with this ruling? So essentially they have to tie it in through their essay and their interview, right?
Essentially, yes. If race is something that is important to them and if they feel that is something of value that they could bring to the institution, they in some sort have to tie that into an essay of some sort. It's not in a manner as if I guess the institution could look at a black student or a student or a Hispanic student and give them any sort of plus or additions based on that.
Yeah, and it is important to note, there was very strong dissent to this ruling, including from Justice Sonia Sotomayor and, Ketanji Brown Jackson, the only black female Supreme Court justice, recused herself from the ruling because she had ties to Harvard University, so concerns about conflict of interest there. But, if you can you kind of express what the basis was for the dissent?
So the dissent was, I guess, I honestly did not look too much into the dissent.
But folks who disagree with the opinion, I guess, what would be the general argument?
So the general argument is that we all know that just historically there's been a basis. Historically, institutions have not, I guess, done their job when it comes to encouraging diversity or just hiring. Not hiring, but admitting diverse students. Hence, the reason that we even have, these type of policies and criteria in the first place.
Mm-hmm.
And yes, the Equal Protection Clause of the 14th Amendment does prohibit discriminating on the basis of protected classes such as race. However, it's no secret, and the court even noted that since the 14th Amendment's enactment, that it has not played out in a manner that it was intended to. Hence, why we have affirmative action like we do now, making proactive steps in order to promote diversity and increase the number of underrepresented students in these institutions does not necessarily mean that that is, I guess, a negative or a disadvantage versus the privileged students or the majority students.
And I want to share, on our website, encourage people to go to our website, atlantanewsfirst.com, because we have a lot more on this story that we keep following. But, the mayor of Atlanta, Andre Dickens, condemned the ruling along with several other Georgia political officials. And you can see here on our website, the mayor said today's decision by the U.S. Supreme Court to end affirmative action programs at colleges and universities will have disastrous effects on families of color who are already grappling with upward economic mobility. And he goes on to say, plainly put, they got it wrong, and I'm gravely concerned on what this means for a diverse workforce like ours in the city of Atlanta. A quality education is a powerful tool, and my administration will continue to do its part to ensure that every child in Atlanta has the support from their village needed to thrive regardless of who they are. And really a lot of outcry here in the Atlanta area. You have Bernice King, Martin Luther King Jr.'s youngest daughter, tweeting, we should not need affirmative action, but we do, because racism, particularly anti-Black racism, persists in our systems, policies, and institutions. Until we change that, decision makers must be made to make equitable decisions. The Supreme Court ruling prevents that mandate. So certainly some very strong reaction to all of this. What are the next steps, Justin, in terms of this?
The next steps, I mean, I would like to think that at this point, institutions understand the issues and the struggles that we have had historically when it comes to achieving equality in education in the workforce. Period. Particularly in the wake of the murder of George Floyd. It seems like that brought a lot of light to what's really been going on. So, I would like to see that even despite the Supreme Court's ruling, that people in higher education and corporate America are aware of the issue and what's going on, and are willing to take meaningful and effective steps to tackle that issue. And despite a ruling by the Supreme Court, hopefully we'll still see some progress.
Yeah. Yeah, very interesting. And this is off of today's ruling a little bit, moving on, looking a little bit more broadly. But we knew that some of the most critical or controversial Supreme Court decisions were expected now in this, over the next week or so, as the Supreme Court is winding down its term, which actually started in October. Do you think that this would have an impact on any other rulings that are that we're waiting for? For instance, we're waiting a ruling on a clash between kind of religious rights and LGBTQ rights. In that case out of Colorado, the Supreme Court is looking at, where a woman wants to have a wedding, basically design websites for people getting married, but she doesn't want to do it for same-sex couples. So they're making a decision on that. I mean, do you think that this has an impact on that, or do you think it kind of foreshadows any decisions to come?
So it shouldn't. I know when it comes to the some appellate courts in the Supreme Court, they make their rulings based on precedent, meaning that they look at prior decisions or prior decisions that have dealt with similar issues to base their future decisions on. And when it comes to this one, I would think that it wouldn't, but I guess we'll have to see.
Yeah, absolutely. Any final thoughts before we let you go?
I just like to say that hopefully this is not the start of I guess a backward steps in the search for diversity. among our institutions. I know we've made some progress. It hasn't been enough, but we have made some progress over the past few years, past few decades, and I just hope that this isn't a backward step.
All right, thank you so much, Attorney Justin Hill, for joining us with your analysis. And we're going to keep following the latest on Atlanta News First, Atlanta News First Plus, and atlantanewsfirst.com. If you haven't yet downloaded our apps to stay up to date with the latest, we encourage you to do that. Thanks so much and have a great day, everybody.